Welcome, everybody. My name is Stuart Hargreaves, and it's my pleasure to welcome you to the latest in CUHK Law's ongoing seminar series. This is the Comparative Constitutional Law Research Forum seminar. Today's speaker is Virginie Kuoch. She is a PhD student at the Sorbonne Law School in Paris. We're very grateful for her to speak with us today. She's going to be presenting on the topic of the use of foreign law by constitutional judges in common law Asia. Promises to be a very interesting topic. We also have with us my colleague and friend Rehan Abaratne, who will comment on the paper that Virginie presents at the end, and then we'll have time for Q&A for you all. If you do have questions for Virginie after her presentation, please send them to me through the chat box, and then I will relay them onto her. We have about 190 people registered, so that'll be the easiest way to do it. So with that said, it's my pleasure now to turn the floor over to Virginie.
Thank you, Stuart. Thank you as well to Rehan for organizing this seminar for me. Today I'm going to speak about my PhD thesis topic, which is on the use of foreign law by constitutional judge in common law Asia. The reason I've chosen this topic, it is because it is a topic that have been studied a lot by eminent scholars, but it's usually on classical legal systems such as the US, Germany, or of course South Africa. Asian legal systems, studies on Asian legal system are beginning to emerge, but it still remains in the minority regarding this topic. Because of the history and the affiliation with the British Crown through the Privy Council, and common law legal systems are more likely to refer and to use decisions from the Privy Council and also from other Commonwealth systems. But is it the case for Malaysia, Singapore, and Hong Kong, which are the three common law legal system, Asian legal systems? The purpose of my thesis is to study the relationship between Hong Kong, Singapore, and Malaysia constitutional judge and foreign law. And foreign law, I will also include international law. Because of their mutual colonial history, this jurisdiction shares some common historical features. However, the judges' attitudes towards citation and the use of foreign law differs. Since 1992, Hong Kong's court, and especially the Hong Kong Court of Final Appeal, refers to foreign decisions. We can see in these 1991 decisions from the Court of Appeal of Hong Kong, stating that decisions of the European Court of Human Rights, as well as those from the European Human Rights Commissions and also the United Nations Human Rights Committee's decisions, although not binding on the court, but would be given considerable weight in order to interpret the ICCPR. Also, inside the Hong Kong Basic Law in Article 84, which is quite similar to Article 39 of the South African Constitution, it states that the Court of Hong Kong will adjudicate cases with the law applicable in the regions as prescribed by Article 18, which is the common law, but also may refer to precedent of other common law jurisdictions. Regarding Singapore and Malaysia, their constitutions don't have this kind of articles and don't have any precedents that allows them to use foreign decisions. However, both legal systems develop this four wall doctrines, which means that the Constitution should be only interpreted within its four walls and without the help from other court. However, in we can see some depart from this forward doctrine from the Malaysian court, as it's written in a 1975 decisions from the High Court, stating that because of the similarity between the Malaysia and the Indian constitutions, they will take into account Indian sources, although they are not binding on Malaysian courts. So my research aim to provide elements that could explain what is the functions of comparative law in constitutional adjudications and why constitutional judges will use foreign law. One of my chapters deal with the definitions of foreign law itself. As I said, because the three jurisdictions that I'm studied have this common law historical background, so it is difficult to define what is foreign law. Our former English decisions are considered today as foreign decisions. Today's English decisions considers as foreign decisions. And in the case of Singapore, as it was part of Malaysia from 1963 to 1965, I was asking myself if Malaysian decisions from that period will be considered as foreign law. Article 8 and Article 18 of the Hong Kong Basic Law state that the common law and all the rules applied before the handover will continue to apply in Hong Kong. But those articles is not really clear on what kind of English decisions would be applied. That's why in a 2008 decisions from the Court of Appeal, the Court of Appeal states that, of course, the principle of precedent is important and should be applied in Hong Kong, and also states that all before the handover decisions of the Privy Council on Hong Kong appeals were binding on the Court of Appeal and others lowest court in Hong Kong. And because of Article 8 and Article 18 of the Basic Law, those Privy Council's decisions, even before 1997, continue to be binding in Hong Kong courts, on the court below the Court of Final Appeal. Therefore, all the decisions between 1849 to 1997 are binding on all the Hong Kong courts. And concerning the decisions of the Privy Council after made after 1997, those decisions only have a persuasive values and not a binding effect. So with the case of Hong Kong, I would consider foreign law decisions are decisions of the Privy Council and the House of Lords after 1997. Those are not binding on Hong Kong on Hong Kong court. But as for the Court of Appeal, all the decisions for the Privy Council and the House of Lords, even those before 1997, are not binding on the Court of Final Appeal. As for Singapore and Malaysia, so Singapore have a piece of legislation called the Application of English Law Act, which deals with the application of common law after 1993. And basically, the Section 3 of this English Law Act is the same as what we can find in the Basic Law of Hong Kong, which states that the common law will continue to be enforced in Singapore. But what makes the difference with the Hong Kong example is that this section 3, paragraph 2 states that in some circumstances, we can have modifications on the common law. And also 1 year after the enactment of this English Law Act, there was a practice statement by the Chief Justice of the Court of Appeal in 1994, stating that it is, of course, important to apply this doctrine of precedent, but also it is important to take into account that Singapore is an independent and sovereign republic, and all the development of the Singapore law will reflect those changes and the fundamental values of the Singapore society, which means that the Privy Council, the decisions of the Privy Council are binding on the Court of Appeal. But if the Court of Appeal considered that, and it's better for the circumstances of Singapore and to take into account the development and the Singaporean society, the Court of Appeal can depart from such prior decisions. But this practice statement only applied to the Court of Appeal, which means that all the decisions of the Privy Council and the English Court will continue to apply and have a binding effect on lower courts. As for the applications of whether Malay decisions are or not foreign law to the Court of Singapore, it's quite simple. All the decisions made by the courts during the time that Singapore was part of Malaysia, which is from 1963 to 1965, are binding on Singaporean courts. And for the Malaysian example, English common law is part of the definitions of the law in Article 160 of the Federal Constitutions. And like Singapore, English law continue to be applied and have a binding effect on Malaysian courts. There's another topic that I deal in my thesis. It's about how the internationalizations of constitutional law. Because of these internationalizations of constitutional law, it will increase judges to use foreign decisions. And in this part, I will talk about international law and the values of international law in Singapore, Malaysia, and Hong Kong. We have three common law systems, which means that they apply the dualist systems. It means that when a country signs international treaties, these international treaties have a legal value inside domestic law only if the parliament incorporate inside the domestic legal systems. Otherwise, those international treaties cannot be used in court and does not have any legal values inside the domestic law. As we can see, Singapore applied these dualist systems. And in the case, this Colin Chan case of 1994, which is very important, states that even though the applicant states that there's a violations of the Constitution, but also violations of International Declaration of Human Rights, the judge say that it will only consider the provisions of the constitutions and other piece of legislations of Singapore and not take into account the International Declaration of Human Rights. Malaysia also have apply these dualist systems, Article 160 of the Malaysian federal constitutions states that law will not include international law, and this is also what the court state in 1981 case, in this Merdeka University's case, in which the judge state that the Universal Declaration of Human Rights is not binding, is not a binding instrument, and cannot use it as a interpretative tool in the case. However, the Malaysian courts encounter some changes regarding international law, as it taken part is in a transnational judicial dialogue with other judges. Since 2005, the 2001, Malaysian court starts to use international treaties as an interpretive source. In a decisions of 2001, for example, these no anak decisions, it was about indigenous peoples in a certain part of Malaysia, and the High Court here considers that Article 4 of the United Nations Draft Declaration of the Human Rights of Indigenous Peoples, the court used the Article 4 of this international treaty and declares that the rights of the native should be protected. There's also a famous case of 2012 called the North Sedilla case. In this case, it was about a decision from the Ministry of the Education, which refused the employment of the applicant because she was pregnant. And the High Court was in favor of the applicant and considers that the decisions is contrary to Article 8 of the Federal Constitutions, which is an article about non-discrimination against citizens. And in this case, the judge said that we can use this international treaty because the constitutions of Malaysia has been amended and took into account this international treaty. As for the Hong Kong example, Article 39 of the Basic Law is about the ICCPR and the legal status of the ICCPR. Since 1992, all the laws which are contrary to the ICCPR, or if the law is contrary to the Hong Kong Bill of Rights, are considered as unconstitutional, which means that the ICCPR and the Bill of Rights have the same legal status as the Basic Law. And in those cases involving the ICCPR or the Hong Kong Bill of Rights, judges usually refers to decisions from the European Court of Human Rights. This, of course, may be explained by the fact that the wording of some articles in both treaties are quite similar. We can take the example of Article 19 of the ICCPR and Article 10 of the European Conventions on Human Rights, on the freedom of expression, they're quite similar. The wording are quite similar. I will continue my presentations on two examples that I took for my PhD thesis and could explain all the difficulties of transplanting some legal principles. They are the proportionality test and the basic structure doctrines. For the last 10 years, constitutional amendment has been one of the most popular topics in constitutional law scholarship, and specifically through the lens of the basic structure doctrine, which is a doctrine created by the Indian Supreme Court, and has spread throughout the world, such as Pakistan, Colombia, or even Taiwan. But what about all the Asian jurisdictions' reactions to this judicial limit principle to constitutional change? Regarding the use of foreign law by constitutional judge, Professor Sujit Chaudhry made the distinctions between universalist interpretation, dialogical interpretations, and genealogical interpretations. Genealogical interpretations means that a court will engage in foreign decisions from a jurisdiction who had a historical link with its own legal systems. So that's why the basic structure doctrine has been exported to some neighboring legal systems, such as Pakistan's and Bangladesh. But we can apply the same idea to Malaysia, because Malaysian's court itself said that the Indian constitutions and the Malaysian constitutions are quite alike. So we can assume that the Malaysian's legal system also imports the basic structure doctrine from India. However, it was not the case for Malaysia or Singapore. They haven't imported the basic structure doctrines principle. In two cases in 1977 and 1980s, both decisions stated that because of how the constitution has been enacted in both systems are so different from the Indian constitutions, therefore we cannot apply this basic structure doctrine. And it's quite and in both cases the Malay judge refers to Indian decisions, but only to reject them and to considers that both constitution and both historical aspect of the constitutions are so different that we cannot import this basic structure doctrine. Here, comparative law is used as in order to consider that the constitutional systems is different than to the Indian one. However, in some Malay case, notably since 2010, we can see some departure from the previous decisions of the Malay court. In these the Siva Rasa decisions, the federal court considers that there could be some basic elements of the constitutions that cannot be amended. In this Semani Jaya and the Alma Nudo cases, the court considers that the older fundamental right could not be amended, or the fundamental right inside the constitutions cannot be amended through constitutional amendment. And we can observe that those decisions appears when there is a mutual respect of between the judiciary powers and the legislative and the executive powers. I will finish my presentations on the proportionality test. Between the three countries that I work on, only the Hong Kong one has apply a structural proportionality test with all the four tests. Singapore, it's the one that refused to apply proportionality test. They tried it in the CUHK decisions of 2005, but again, the High Court considers that because there is a difference between the English law and Singaporean law, that we cannot apply this concept, this European concept. It's to me, it's not just some cultural differences that prevent the Singaporean judge from applying the proportionality test, but it is more about the lack of autonomy of the judiciary, because in Singapore, 90% of the Singaporean parliament is composed of the People's Action Party's members since 1959. So from this time, a robust constitutional review of law is adopted in Singapore, and until today, there is no law or administrative act that has been declared unconstitutional. As for Malaysia, it's quite interesting to see that the decisions on the basic structure doctrines and the decisions that try to apply the proportionality test are the same in both kind of in those decisions of 2010 to 2019. The Malay's court use a lot of reference in order to import the proportionality test, such as, of course, the Canadian Supreme Court's decisions, the R and Oak's decisions, and also all these decisions of the English courts. As for Hong Kong, since 2016, the court admits that the proportionality test is composed of 4 steps. However, in those decisions, the last steps have not was not applied. The court only applied the 3 tests. For example, the Hysan's decisions, the Court of Final Appeal refers to ECHR cases, but not to enhance the protections of human rights, but they refer to the ECHR cases in order to import the margin of appreciations which give and the court considers that this is the better principle to apply in those cases, and link with the conceptions of deference. To conclude, we can see that because the jurisdictions that I've studied are quite new, recent. They have less experience with constitutional adjudications if you compare to the countries in Europe or the US. That's why they will look at experience from all the courts to develop their own constitutional story. And the reference to foreign law also serves another purpose. We can see with the basic structure doctrines and the proportionality test that the court will still, except in the example of Singapore, but the court will still use foreign decisions, but in a differential way to the executive and the legislative power. Thus, using comparative law doesn't necessarily mean that the judge is becoming more active. Okay, thank you very much.
Thank you, Virginie, for that very interesting presentation. So as I said, we'll have a Q&A session later. So if you have questions, please do submit them through the chat box to me. But now it's my pleasure to turn the floor over to my colleague, Professor Rehan Abaratna, for his comments on Virginie's presentation.
Okay, thank you, Stuart. And thanks very much, Virginie. So, Virginie was in Hong Kong a couple of months ago, and I mentioned to her then, and I'll say it now, I think this is a great project. It'll be of interest not only to scholars and practitioners in the three jurisdictions she's looking at, right, Hong Kong, Singapore, Malaysia, but I would say to scholars of comparative constitutionalism around the world. As she pointed out at the beginning of her talk, there really isn't much academic work looking kind of comparatively, especially at the use of foreign law in Asia. I would also say that her approach, which is not purely doctrinal, but there's kind of a historical aspect and an institutional aspect with the sort of separation of powers, I think is terrific. And I think that's sort of very much the way that these projects should be approached. The only other work that I can think of that's similar is David Law's work on judicial comparativism and diplomacy in Asia. He also looks at Hong Kong, but he looks also at Japan and Taiwan. But it's a similar sort of multifaceted comparative analysis. So I think, again, this work is very welcome. And, I very much look forward to seeing the final product, not just the thesis, but hopefully eventually also a book. I don't want to pressure on you, but I assume that is the outcome. So my comments now are going to kind of flow from the presentation that Virginie made, and also a paper that she circulated to Stuart and I a few days ago. And I just want to, my comments are aimed at sort of trying to understand a little bit better kind of what the central research questions are in this project and exactly what you are looking to examine. So let me start with some comments and questions about the case selection. So Virginie says she's interested in Asian common law legal systems, which she defines in both legal terms. So, the fact that they rely on the principle of stare decisis, for instance, right? Judge-made law, precedents are binding. And also in historical terms, right? A shared British colonial history, including a reliance for a long time on the Privy Council, right, as the sort of highest court. And so I have a couple of things here that I want to push you a little bit on. So the first is about the kind of common law, civil law distinction. So, the German scholar and former judge Dieter Grimm has made this point, and I'm sure others have as well, which is the common law, civil law distinction is very meaningful in private law and even in criminal law, but it becomes less relevant in constitutional law for a couple of reasons. One reason is just the kind of general convergence, and you kind of get to this in your talk actually, of the ways constitutions are written, right, around the world. So most constitutions, especially those written since World War II, look pretty similar, right? And so whether you're in a civil law jurisdiction or a common law jurisdiction, your constitution is going to look pretty similar, right? It's going to have a set of fundamental rights, it's going to have some kind of separation of powers, it may have some kind of fourth branch institutions, etc. And so in terms of kind of constitutional text, there isn't much difference. And then also in terms of the way judges adjudicate constitutional cases, right? So proportionality is a good example, but there are many other examples of doctrines and approaches that have really spread around the world, right? And so again, going back to David Law, he calls this generic constitutional law, right? Constitutional law is just sort of very similar around the world. And so the reason this might be relevant here is that I'm not sure what the fact that these jurisdictions are common law jurisdictions is doing for your project, right? So as a legal matter, as you point out, there are some similarities, right? So like dualism in the interpretation of treaties, that is quite a common law feature. But I wasn't sure exactly how those kinds of similarities then kind of have an impact, to the extent that they do, on how courts actually decide cases or how they use foreign law, right? It seems like other factors may be doing much more work, like the relative democratization of the society, the type of judicial review that they have. It just seems like those factors would be much more relevant than whether or not, as a legal matter, they're a common law jurisdiction. So that's on the legal side of this common civil law sort of distinction. But as you rightly said, there's a second part to this, which is like there's a shared history of colonialism, British colonialism, and sort of the lasting influences of certain British institutions, especially the Privy Council. So at the level of kind of history and kind of judicial or legal culture, there probably are some continuities and interesting similarities between the three jurisdictions you've selected, but I think those need to be drawn out in more detail, right? Exactly kind of what those are, aside from the fact of having the British there and the Privy Council there, and kind of how they've continued and how they've been reshaped in a post-colonial environment, I think could be drawn out a little bit more and defended a bit more. So this is not to say that you should like abandon your case studies. I think it's just to kind of maybe enrich your discussion of them and sort of explain kind of what they're doing. And on a related note with case studies, and maybe I'm a bit sensitive about this because I'm South Asian, I was under the impression that the Indian subcontinent is part of Asia. And those are common law jurisdictions too. So, it's not, again, obvious to me why Malaysia, Hong Kong, and Singapore are the three case studies you use. I mean, as you mentioned with the basic structure doctrine, actually Malaysia has a lot in common with India, right? Arguably more so than it does even with Singapore, right? So I'd like to hear a little bit more from you. And I think in the project, you should probably say a little bit more about why not those Asian common law jurisdictions, because again, it's not obvious to me why India, for instance, wouldn't be a good case study. And I think it would also be helpful to say, hey, I'm bringing Malaysia, Hong Kong, and Singapore together because together they tell us something interesting, or together they contribute to my project. So if you can make a claim like that, I think it would really, really strengthen that part, or that choice. I have a few comments as well about the specific claims you made. So the point about English law was very interesting. I hadn't really thought about this idea about whether English law is foreign law or not. And I think that's a very interesting theoretical question. And something at least I hadn't heard before, very, very original. I do wonder though, if that's what you're actually focused on, right? So, I mean, is it really, so aside from whether courts can say that they treat them as foreign or not, but it seems like what you're really interested in is whether British decisions, especially from the past, have continuing legal force, right? The extent to which they're binding and the extent to which they continue to influence the way these courts operate. So I wonder if that can be reframed a little bit, right? So kind of whether or not they're foreign is kind of a binary thing. That's an interesting theoretical question, but I'm not sure that's what your actual focus on, because when you started to talk about kind of the application of English law, you're getting into much more detail, right? Article 8 of the Basic Law, the application of English law in Singapore. It's much more about kind of what is the continued actual legal relevance of these cases, right? And how does it shape the legal systems going forward? Finally, on the basic structure doctrine and proportionality, I have a couple of specific thoughts and then a couple of broader thoughts. So on the basic structure doctrine, you note that the Malaysian federal court has recognized the doctrine, and the Hong Kong and Singapore courts have not. But I think there needs to be a little bit more discussion about that, especially with respect to Malaysia, because when you say Malaysia adopted case Sivananda, that makes it sound like they are using a judge-made doctrine to strike down laws duly enacted by the parliament, when of course that's not the case. So far, they've only used it to read down laws, right? So they use it to kind of limit the scope of laws as opposed to striking down laws, which is different. And there may be good reasons for that, but it is different. I think that needs to be drawn out. And moreover, I don't think you can stop with the Al Menudo case, because the more recent case, Maria Chin, the court seems to actually abandon the doctrine, right? And so I think, you need to say a little bit more about kind of what Malaysia is actually doing, right? Did they just kind of recognize this doctrine in that brief window when the Barisan Nasional lost, and now that kind of normal order is restored, they've abandoned it, or is there something more going on? So I think that needs to be deepened a little bit. And I had a similar thought on proportionality. So again, at a formal level, it is true that Singapore has not adopted the proportionality test, but they kind of effectively did a couple of years ago. So there's a case called Wam Kuoch Jolovan versus Public Prosecutor, where the Court of Appeal adopted a three-part balancing test to determine whether a provision in their Public Order Act violated the right to free speech, assembly, and association under Article 14 of the Singapore Constitution. And so the court didn't use the term proportionality, but it effectively did proportionality. So the steps it went through were, number one, was the restriction necessary or expedient to advance one of the enumerated interests under the Constitution? Was there a nexus between that and the purpose of the legislation in question? And then a sort of related sort of step about whether that would be a permitted purpose, right? So it's pretty similar to proportionality. So I think, again, you need to kind of deepen the analysis a little bit. So we can't kind of just go by what courts say. We need to actually look at what they're doing. And that kind of, I think, takes us into a more sort of granular look into the case law itself. And then finally, on both doctrines, I wasn't quite sure the argument you were making about the way these doctrines have been adopted or not versus these courts' use of foreign law. So is it a strategic kind of argument that you're making, that these courts kind of want to be seen to be using these doctrines, but in fact are not really using them? Or is there a way in which, so let me maybe put it a different way. So are you saying that that the foreign law, and I'm taking it that you take proportionality and basic structure doctrine as foreign law here. So what work is that doing in these jurisdictions, right? So is foreign law kind of contributing anything of value in these jurisdictions? Or are these jurisdictions, are these courts kind of cautious and strategic anyway? And then are they using foreign law in a sort of strategic way, right? And so I'd like to hear a little bit more about what the causality is, right? Is it the foreign law doing the work, or the judges kind of using the foreign law sort of just in a very sort of, superficial way, shall we say, but not actually adopting these doctrines at all, right? And with that, I would also sort of add that, again, I'm not sure the relevance of the common law jurisdictions here. And you said this yourself, right? Like, proportionality is everywhere. It's a German doctrine, it's everywhere. So it wasn't clear to me why proportionality in these three countries is especially interesting, right? Or these three jurisdictions is especially interesting. The same with basic structure doctrine. Yes, it's originally from India, and yes, Malaysia did reference their common history, but as you noted, Taiwan has adopted it, Thailand has adopted it, right? Many non-common law jurisdictions have adopted it. So again, I think there's some work to be done to sort of explain what is it about these jurisdictions kind of that brought together, make an interesting study, and kind of what's the claim you're making about all of them and their use of foreign law. So with that, I'll stop. Thanks again, Virginie. Really enjoyed the paper, and really best of luck going forward.
Thank you, Rehan, for those comments. Virginie, is there anything you want to respond? I mean, obviously you can't respond to everything that Rehan just said, but do you want to talk a little bit more about your choice of jurisdictions to study, or perhaps, so maybe that's one thing you can answer, and then the second, perhaps, what it is you want us to take away about the use of foreign law in those jurisdictions? Could you maybe expand on those points?
Yes. The reason I chose first, I start all my case studies on those three jurisdictions, but of course sometimes I will compare with, for example, the Indians examples. So my starting point is on those three common law systems, but I will also compare with other jurisdictions nearby, like the Taiwan example, and also the Indian one. And the questions about the relevance of common law, the reason I chose these three jurisdictions because, as I said, and I point, it's of course their historical similar features, but also the fact that at first, Malaysia and Singapore are very reluctant to use foreign decisions. They use it in a kind of informal way, but they have in their own decisions clearly stated that we are not going to use foreign law, which is totally in opposite with the Hong Kong examples, and that's the reason I chose those three jurisdictions. Because I don't think that there's other Asians common law systems that say it explicitly that we are not going to use foreign law. And also there's a reason that I chose Singapore. It is because in terms of international arbitrations, international commercial law, they are quite open. They're very open, but when it comes to constitutional law issues, they are more reluctant to look at others examples. And for example, in Singapore, they have a international commercial court with foreign judges, the same as we can find in the Court of Final Appeal in Hong Kong. But there's no this kind of foreign element inside the Court of Appeal itself. And yes, on the English law aspect, the historical aspect of English law, my first question, because in my thesis I needed to define the whole topic in the introductions or in the chapters. So in order to define what is foreign law or not, I need to define what is, I need to look at what is binding or not, the binding effect. So that's why I make these distinctions between precedents that are binding and all the legal materials that are not binding. And so in my thesis, I make the distinctions between the binding effect and the persuasive effect in order for me to know what kind of decisions to read and what are the decisions that the judge use.
Thanks. So in your research so far, I mean, it may be a bit of an early stage, but do you see a difference in treatment between, as you say, specific precedents or perhaps specific applications of case law currently versus, I don't know, perhaps the broader incorporation of principles, I guess we could say principles like basic structure doctrine, like proportionality? Are you treating those as different because the courts are approaching those in a different way in your research so far, that they're more open to one than the other? Is that what you're saying?
Yeah, it's they are more they're more open to one than another.
And which one are they more open to?
To principles.
To the broader principles.
To broader principles, because it's more easy to refer to a broad principles, and because they usually use those, because they are it's easier to apply those broad principles than specific decisions. Although sometimes they, like for the Singapore and Malaysia case, they usually apply some decisions that are quite well known, and they apply it a lot in their own decisions. So it's turned out to be they usually have a reference to those decisions.
I have a question.
Oh, go ahead.
Sorry, no, Rehan, please.
So just on that, Virginie, so I kind of want to go back to a question I asked. Maybe I'll just ask it with a specific example in mind. So you note that in Singapore, the courts have been more willing to use the Wensbury principle, right? Or the Wensbury test rather than proportionality. And so can you say a little bit more about why you think that is? So is it because it's an English decision? Is it because it's a conservative decision? Or is it because it's easy to apply? Or is it some combination? So I think what both of us are trying to get at is kind of what's doing the work here. Is it kind of strategic considerations of the court, or is it some kind of actual, what we might consider a legal question of, hey, this is a British judgment, so it's more applicable to us, right?
I think it's both. They will use a English principle and considers that in English administrative law, English constitutional law, it's they usually apply this Wensbury reasonableness, and then they will still, of course, refers to English decisions, but in order to avoid applying the proportionality test. So it's they will use as a strategically as a strategy to be conservative, to have a more conservative decisions. So it's a so here the foreign law is not using as to be more protective to human rights or anything else, but just to support their conservative positions on the questions.
Thanks. So a related question I had was your discussion, or you mentioned both the presentation and your paper on dialogue. So I guess there's different ways we can think of dialogue, right? We can think of dialogue as institutional dialogue domestically, so dialogue between the courts and the executive and the legislative branches, for instance. That's one kind of dialogue. There's also that kind of intrajudicial dialogue internationally in the common law world, minus the United States. We can see courts citing each other a lot in the principles that you've talked about. But then there's also that kind of elite level judicial dialogue where it's that personal interactions that judges themselves have with other judges, particularly at apex court levels, and they're going on conferences and they're becoming friends with one another. And so when you talk about dialogue, and I know you've had some interviews with judges as well as part of your research, when you talk about dialogue, what kind of dialogue are you thinking of, and what effect is that dialogue having on what you see these outcomes being?
Yeah, I started my thesis on the idea that there is a dialogue among judges, that they go on conference, they meet, and this and as David Law also pointed out in his article, is that there's more and more dialogue, personal dialogue between the judges, and it's also there's also through conferences between courts there is a dialogue, institutional dialogue, but there is also a dialogue between the different powers inside a legal systems. Like if we take the examples of Malaysia and Singapore, there's two kind of, they will cite just reference from abroad, but in order to have a more constructive dialogue with their own powers, the executive and the legislative powers. So dialogue, the judicial dialogue, turns to be a more inter-powers dialogue between inside the systems.
Great. Rehan, any follow-up questions? And again, if the audience has any questions, please do send them in to me. All right then. Well, that brings us to the end of this seminar.